Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 unanswered questions of Texas non-compete law. If you read my blog, 5 Minute Law, and really if you don't, you should, but if you do, you already know that I'm counting down these unanswered questions to celebrate the 30th anniversary of the Texas non-compete statute, which is coming up next month. All right, so what are these great mysteries of Texas non-compete law? Number 5 is this. Is the reasonableness of a Texas non-compete a question of law or a question of fact? If you've read very many non-compete cases in Texas, you've probably seen a bunch of cases that say it's a question of law, but I'm not so sure about that, and I have a blog post where you can read about why. So that's number 5. Number 4 is, does a Texas non-compete have to have an express geographic limit? Now again, some of you might say, wait a minute, why is that an unanswered question? It's right there in the Texas non-compete statute. It says it has to have reasonable limitations, including geographical scope. Okay, but there are some cases that have said that you can have some other limitation in lieu of a geographic limitation. So I think that remains an unanswered question. The number 3 unanswered question of Texas non-compete law is related to the geographic limitation, and that is, can you get reformation from a judge if the non-compete is totally missing one of the 3 reasonable limitations that the non-compete statute says it has to have? And those are geographic area, time period, and scope of activity. So for example, what if there's just no time period whatsoever? Now, if the time period is too long, the statute is very clear. The court is required to reform it to the extent necessary to make it reasonable. But what if there's just no time period at all? I saw a recent case where the judge said, if one of these things is just missing entirely, I'm not going to reform it. But I think that remains an unanswered question. The number 2 unanswered question of Texas non-compete law is whether there is proof of irreparable injury when there's evidence that an employee is taking customers from one company to another. This is the most common scenario that you have when the employer tries to get a temporary injunction to enforce the non-compete. Does evidence like that establish irreparable injury? Sometimes judges say yes, sometimes they say no. I have a theory for what's really going on there, and again, you can read about that at my blog. Finally, the number 1 unanswered question of Texas non-compete law: how confidential is confidential? What I mean by that is that the Texas Supreme Court has said very clearly that one way a Texas employer can make a non-compete enforceable is to tie it to a confidentiality agreement. But when an employer does that, the Texas Supreme Court said in a case called Sheshanoff that the employer has to actually provide the promised confidential information to the employee. And it's at that point that the non-compete becomes enforceable. Is it enough for the employer simply to say that the information is confidential, or does the judge have to kind of dig into the issue to figure out if it's really confidential or not? There was a recent case where a judge was skeptical of the employer's claim that the information was confidential, and therefore the judge said, I find that this non-compete was not enforceable because the information the employer provided regarding customers and pricing it just didn't satisfy the judge that the employer had actually provided confidential information. So those are my top 5 unanswered questions of Texas non-compete law. Is there an important unanswered question that I missed? Or maybe you think that one of my unanswered questions is actually an answered question. If so, let me know, and hey, thanks for watching.